Hey there, and welcome to Lady Justice, Women of the Court podcast. In the final episode of Season 2, the Lady Justices host a live remote podcast with Professor Charlie Oldfield's judicial drafting class at the University of Akron School of Law. Today, the Lady Justices discuss their paths to becoming Supreme Court justices, how being a justice influences their writing style, and the importance of writing judicial opinions in plain language.
What's cool about a state Supreme Court is that you are announcing and clarifying and sometimes settling issues that have been unsettled for some period of time. It's a big responsibility, and how you say that matters.
They also answer questions about highly sought-after clerkships with state Supreme Courts, share details about the hiring process, and discuss the qualities they look for when hiring a law clerk. The lightning round will focus on plans for summer vacations, role models who impacted how the Lady Justices carry themselves in the courtroom, and their funniest Zoom experiences. Finally, the Lady Justices open the floor for student questions. Enjoy today's episode and stay tuned for some exciting information about the Season 3 opening of Lady Justice, Women of the Court podcast.
Welcome to Lady Justice, Women of the Court, a podcast ranked number 9 on the list of top 30 court podcasts recently named over at feedspot.com. I'm Justice Beth Walker, the Supreme Court of Appeals of West Virginia, and with me today, as always, are my friends Chief Justice Bridget McCormick of Michigan and Arkansas Justice Rhonda Wood. It's been a little while since we've been together, so let's start with a quick hello. Rhonda, what's new in Arkansas?
Hi. Well, I totally forgot that we were going to have like an Ohio, Michigan, like throwdown, and that, I'm like here moderating that. But in Arkansas, we handed down our last opinions for the term this morning. The other thing, Arkansas is in the semifinals of the baseball national championship. So if we win at 3:00 Central today, then we are in the finals. So Arkansas, we're pretty excited to that. I just spoke at our Arkansas Association of Counties meeting, and they actually had the TV up in the room because everyone's ready to watch that. But anyway, that's sort of what's new in Arkansas. What about you guys?
How about you, Bridget?
Gosh, so I wish we were close to done with our court's term. We are not. Our term always finishes July 31st at midnight unless we get our work done earlier. That's not going to happen this year. There's been a lot. In addition to the regular cases, we've had an awful lot of election emergencies. I think there were 38 candidates who were thrown off the ballot in Michigan. We had a very busy late May and June, as you two might imagine, from that number. Also, like everywhere else, it's a redistricting year, but for the very first time this year, we had an independent redistricting commission. So the first time through, you get a lot of new legal questions about how all that is going. So I think that's contributed to our very busy summer. We're going to be busy for the rest of the summer. Congratulations to the Ohio State. We're having fun with that on Twitter. Go Blue. What's happening in West Virginia?
Well, thank you for being gracious as always. For those of you who don't follow us on Twitter, we've had a long term, although I have spent my whole professional career in West Virginia. I am a Buckeye from birth at heart. And so Bridget and I do go back and forth a little bit about the Ohio State and Michigan thing. But it's very friendly, and I'm just grateful that we actually have a football rivalry again. It was a long time coming. And there we go. So what's new in West Virginia? Our Sine Die Day was last Wednesday, and all of our opinions were released actually on Tuesday. We have 2 terms of court, January to June, and then September to November. So we have pretty finite timeframes, and we stick to those deadlines. And we routinely, as we did this term, issue opinions in every single case we hear during the term by our Sine Die Day, which I recognize I'm pronouncing that incorrectly, but that's how we say it in West Virginia, is Sine Die. So I'm going to stick with it. Lots of other fun things going on. We have a brand new justice, finally, another lady justice in West Virginia. We have 2 of 5. Our new Justice Haley Bunn joined us in May. And we are launching a brand new Intermediate Court of Appeals. We have been a one-step appellate state for a very well since we started. And we now will have that extra Intermediate Court of Appeals step. That court goes up and running on July 1. So lots happening in West Virginia, even though we are done with our term. So today I'm excited that we are doing a live remote podcast. So we have a live audience via Teams, actually, which is fun for us. We have a lot of fun seeing each other, but it's also fun to know that people are actually listening. And so these students are being held hostage to our witty conversation, I guess. We are speaking to Professor Charlie Oldfield's judicial drafting class at the University of Akron School of Law. And this event came about, as many great things do on our podcast, by way of Twitter, where we're all friends or followers or whatever we call each other on Twitter now. When Professor Oldfield reached out to us a few months ago about speaking to his class, we were able to juggle schedules and make it work today. So good afternoon, everyone who's in the class. We can't see you, but we know you're there. And welcome to our live podcast. Our format is that we're going to discuss a few topics that our friend, the professor, has suggested, and then we will open up the floor for questions. So students, you have a little bit of time to come up with questions, but if you don't, keep in mind that two of us, as you heard in introductions a little bit ago, are experienced law professors and know how to call on people. So I know you'll probably come up with questions. So just to kick things off, let's start with a little background information. And our first question, what was your path to being a justice on the court? And how do you think that influenced your current writing style? Bridget, will you start for us?
I will. I love this question because I don't think I had ever thought about the connection between my background and my writing style, and probably there is one. So I think it's a smart question, Beth. Thanks for thinking of it. I was, as you heard, on the faculty at the U of M Law School very happily for 12, 13 years when I made a rash decision to run for statewide office, and to everyone's surprise, including my own one. So my path was a little random. I did not set out to be a judge. I was a very happy lawyer. Even though teaching, I taught primarily clinical classes, and continued to lawyer happily in that context, including in a lot of appellate courts and the Michigan Supreme Court. And so running for office was not something I spent a lot of time thinking about. And I think that was probably wise. If I had thought much more about it, I might never have done it. But I landed myself on the Michigan Supreme Court in 2013. And I think that my background as an appellate lawyer and an appellate teacher, I mean, my students were doing a lot of appellate brief writing, probably does have an influence on my writing style. I spent a lot of time with students trying to help them think about telling a story in a way that keeps the reader reading, like, beyond the page 3, and how to do it in clear language, in plain language. And so I think a lot of that carries through to my own opinion writing. I always, when I write an opinion, I try to imagine people reading it who are not lawyers. And, it seems to me pretty important that everybody understands what the law is. And if we don't do a good job communicating it in language that people who didn't go to law school can understand, I feel like we haven't done a great job. And so, I feel like that was something I spent some time on in my last career, and it's carried through. So I thought this was a fun question. What about you, Beth?
Well, thank you, Bridget. On this podcast, we've had a great time, and we've talked to different audiences and had some questions. So now it's challenging because I'm always trying to come up with something we haven't talked about before. So that's where this one came from. And three of us have a lot in common. We're all, I'm sure we'll mention it at some point, first generation lawyers. But the one thing that I don't have in common with my friends is that I don't have an academic background. I didn't teach. I haven't yet. I'm sure I might at some point. I would probably enjoy it. Taught at law school or in higher education. So my background is all from private practice and being an in-house lawyer. And in that role, it's just a different background. It's not any better or worse. And I think, we talk about this too. I think you have to have judges that come from everywhere. you need to, everybody, if you have all the judges that came from the same background, we'd all come up with the same thing. And part of the wonder of our jobs is just the back and forth in discussing things. But I always worked a lot because I was a labor and employment lawyer with human resources folks who, by and large, are not lawyers. So a lot of my interaction day to day, in addition to jury trials, I didn't do a ton of appellate work as a lawyer. So it was some trial work, a lot of administrative hearings, and working with non lawyers. And that made me very practical. I was always looking for ways to sort of get to, cut to the chase. And I wasn't that enamored with showing off about how fancy my legal analysis was, because my clients really didn't need that. And it's not that they didn't care, they didn't need it, and they might not understand it. And I didn't want it to cloud what I was trying to tell them was my advice. And so I'm always, and I think it affects my writing style now because I'm very practical. I like to start out opinions so that you can read the first paragraph or two and know exactly what the opinion's about. And I think we all work on that in different ways. And sometimes, of course, and we'll talk about this more, my law clerks have to say, Beth, you need to do a little analysis here. And I say, yeah, you're right. Because sometimes I'm a little too practical and a little too cut to the chase. But I definitely see how a very sort of practical legal background influenced my writing style now. How about you, Rhonda?
Yeah, this is a great question. I think probably what influenced me the most coming immediately to the Supreme Court was I'd been right before that 2 years on our Intermediate Court of Appeals. And on our Court of Appeals, all we did really was we would have a case and we would look to say, what did the Arkansas Supreme Court say on it? And then we took that case and we applied it to the facts in front of us. And that was our job. And if there wasn't an Arkansas Supreme Court case on it, then we asked the Arkansas Supreme Court, would you take the case and make a decision and tell us what the rule or the law is on that? And so doing that for 2 years and then going right to the Supreme Court, it made me very aware of making sure every opinion we had clearly said, if it's an issue of first impression, here's the parameters. Here's what we mean, here's what we don't mean, and that we don't say more than we need to say, and that we sort of haven't opened it up wider than it is. And I think that that's not only impacts probably how I write, but probably how I edit my colleagues' opinions. So I definitely that experience right before coming in the Supreme Court made me view it not just writing about the decision in the case in front of us, but being very cognizant of how it's going to be used as precedent in the future.
That's a really great point. And as we have a new intermediate court, I'm going to remember that because I think it is a brand new dynamic when you've got another set of appellate judges who are going to be weighing in on things. So thanks. That was a great start. Now, I know that a lot of the folks in our audience are students who have their eyes on judicial clerkships. And I know I can speak for my friends when I say that clerkships in state Supreme Courts are by far the best experience, no matter what others may say, far and away. So let's start by discussing our law clerks. How many clerks do you have? What's your hiring process? And what do you look for when you hire clerks? And I'll kick this one off and say that first, I have 4 law clerks, which is a lot as when you compare to other state Supreme Courts. We are a busy court, as I said. We've been the only appellate court for a long time, and we handle a whole lot of cases. Our review is not discretionary. We take every single thing that comes in the door, and that just takes a lot of work. So I have 4 clerks. One of those is a term law clerk, somebody who does a 2-year term and is a relatively recent law school graduate. And the other 3 right now are what we might call career clerks. That's how we get our work done right now. I've added just very recently, I'm in the process of adding an administrative clerk to kind of help keep the trains running on time. That person will also be a recent graduate. And I am right now, the only one on our court of 5 justices total. You can see our beautiful courtroom in the background, Professor. That is for you, because I know you love our West Virginia courtroom. I'm the only one who hires recent graduates. Everybody else has career clerks. And I am a big proponent in the educational component of our state Supreme Court and these positions. And as we go forward, if any of my clerks ever get tired of me, which is possible, I will add more term clerks as I can, because I think it's really great to bring in new folks. It takes more time. It takes a little bit more training, and we'll probably talk about that. But in terms of what I'm looking for, because we have this team, I am looking for folks who can be part of the team, who can get along with the folks who are here. And so, actually, my hiring process when we post is I allow my current clerks to screen the applicants. I say, I want to know who you all think would do well in this job. You do this job. And, we have a very team oriented process. We collaborate a lot. We don't sit in silos. We talk a lot on Teams or in person. And so, really, they do a lot of the decision making. And you might think, well, you're abrogating. Not at all. I just am very realistic, again, practical about who's going to succeed. And I think my folks know probably as well as I do who's going to succeed. I make the final call. I meet with finalists and figure out who would be a good fit. But that is my process in West Virginia, as I'm sure in the other states. It's a discretionary position with me. I don't have to go through the other justices or anything like that. We each have our own staff. So, Rhonda, how's it work for you?
So probably pretty similar in a sense. We have two law clerks. So I have an administrative assistant and then two clerks. Up until most recently, I always had one that was sort of permanent clerk and then one that rotated. And so, but I guess I feel like there's a base level that sort of you're competent enough. If you're going to get an interview, then you can do the job. And I have a lot of people that intern that probably I wouldn't clerk, but I give them that opportunity for that educational experience just to be help them while they're in law school. But if they make the interview stage, then they're competent enough. They interview with my whole staff with us. So there's 4 people in the office. So we would be down to 3 when we're interviewing. And so they interview with all 3 of us. And at that stage, a lot of it is, really how well you can fit in our environment. And when you're clerking, you know everything pretty much, I feel like, about my life. I have to be able to trust you, and I have to have a feeling that you can get the job done. And I want to have someone that's going to challenge me, that's not going to be a yes, yes, yes person, that will push back and that I can have that conversation with. And so they'll come in, it may be in 10 minutes. I'll cut the interview and it's done because I know right then it's not going to work out. Usually if it's close, the interview will go an hour, hour and a half. Then we'll know, yeah, this is going to work pretty quickly, that I can start getting a feel that this person is going to, be receptive to what I need in a clerk and be willing to challenge me. And that's the main thing I want is I want someone to challenge me. So, Bridget, what about you?
So I'm going to tell you all about me, but I have one more. I have a follow-up question for Beth. I didn't want to interrupt you. Your admin clerk, is that one of your 4, or do you now have a 5th clerk?
So we have my colleagues have an administrative assistant, and at the current point, none of those folks hire a lawyer to do that. So I, as you know, have not had an administrative assistant, and I've decided to bring in a lawyer, a brand new lawyer, to that role. And so that is an additional clerk, but really, it's gonna be so it's a brand new position. I was actually inspired by our friend in Texas, Eva Guzman, who had an administrative clerk, and I decided to give it a try. So it's a new thing.
Excellent. Okay, cool. So I have 4 clerks like Beth does, but I have sort of the opposite of what she has. I have a senior permanent clerk who's been with me since I started. And then I have 3 term clerks, and they all serve 2-year terms. They start with me in September and they stay for 2 years. I mean, I guess they could leave early, but they don't usually. And so every September I have somebody leaving and somebody coming in. So each year I'm looking for one new clerk, usually for 2 years out. I'm usually hired a couple of years out. And I do the same that you do, Beth. My senior will do the first cut in a set of applications and show me the ones he thinks I might want to look at pretty closely, and then I'll bring in a few finalists, and I have them spend time with all of the clerks in the office. even the one who they might be replacing, just to have everybody be able to give me their sense of the candidate, and the candidate get a good sense from each of them about the job. It can be a lonely job. I want to echo what Beth started with, which is that I think the clerkships on state Supreme Courts are far and away the best clerkships. They really are. They're just, you get to do every kind of case. Courts of general jurisdiction are just super interesting, and you're deciding important questions, and you're the court of last resort. And so it's I think the most exciting clerking job out there. But all clerking jobs can be a little lonely, right? It's a lot of time in your own head and time reading and writing, and you want to make sure that that's what somebody really wants to do, because if they're going to come do it with me for 2 years, I'm going to invest a lot of time in them, especially that first year. And I don't want them to be miserable. I want them to love being there. So I figure if they have time with each of my clerks, they can ask all the hard questions that they might be embarrassed to ask in front of me, and maybe they'd still be embarrassed to ask them, but I don't think so. It's a little more comfortable, I think, to get real information about what the job entails. So that's about the process.
Well, now we know who does the work in our offices, and now I want to shift over to how that work is done. And to start this part of the conversation, I'll say that I'm sure that every judge works differently with clerks and how they use clerks and what the process is. And so I don't know that we've ever talked about this on the podcast. I don't remember doing it. This is a fun new question as well. And so I'm going to ask, and Rhonda, I'm going to have you go first because you have been both a trial judge and an appellate judge. But can you give our students an overview of how you work with your law clerks and maybe even how that's evolved over your time as a judge?
Sure. And I'll say it's really different. When I was on the trial court, the law clerk did a lot of docket management. That there are standards for how quickly cases need to be resolved. And so that clerk really was all about making sure that every case was moving through quickly and keeping track of when cases were filed, doing scheduling orders, making sure cases were set for trial, and then really only researching complex motions and writing memos on complex motions, but really sort of managing the trial docket, and did a lot with jury instructions. That was the other main area that my trial court law clerk worked on. Both at the Court of Appeals and Supreme Court, the clerks don't really do any management, caseload or anything like that. The way they work is at our court, we get the cases 4 weeks before the court conferences the case and has argument. So we come up, we get the case. My law clerks have, I'm trying to think, they have about 15 days. No, it's a little bit less than 2 weeks. They have to write their memo on it, and they write me a memo. I do my own research, and I will come up with sort of where I think the case is. They've written their memo. I read their memo. Then we all get together, all of us, and they present it to me. I kind of talk about it. It's more like hospitals' grand rounds that they do with residents. So they will present the case with the other clerk being there. And then me and the other clerk who has not worked on the case, we will ask them all kinds of questions. And at that point, I will tell them I have agreed, or I will tell them that I think they're just completely wrong, or there may be different issues. And we just argue it sort of back and forth, and we flip it around. If we're in agreement, I may say, well, give me your best argument against why should we be wrong? Have the other law clerk argue. And then at that point, I'll say, we feel comfortable on the law. If we know, we will know at that point if we would be writing the majority, if we get the majority, then I'll say start drafting a majority opinion. If there are certain areas, I'll say I need more research on this, or I need more research on this. I don't feel comfortable, and they will go back. There may be times where I'll say, what I'm all about because of the trial court, what did the third amended complaint, what did they actually ask for in the prayer for relief? And they get so mad when I ask them that because they've spent all this time on the law, And I'm like, but did they actually ask that at the trial court? So I ask a lot of record questions. But anyway, we go back and forth. They usually draft the first opinion if it's majority opinion. I always draft my dissents and concurrences usually, do the first draft of those. And then we just edit back and forth. We may go through 16 to 20 drafts of an opinion or a highly editing before we send them to the court. We do a lot of drafting. I know that makes you cringe. The other thing, I think I've mentioned this before, we make each other especially on certain opinions, we read each sentence out loud because I've been sort of burned by a sentence being lifted and taken completely the wrong way. So every sentence sort of making sure, especially in a dissent that's going to be published, that we'll read each sentence out loud and make sure that if that's the sentence that's published and gone kind of worldwide, that sentence is not going to be misinterpreted. So we do that as well. I don't know if that helps you guys or not.
That's great. What about you, Bridget?
My clerks work on, I think of it as three different buckets of work. So they're constantly working on each of those buckets. One is incoming applications for leave. My court is a 100% discretionary court. We decide our own docket. So we review in a given month 150 to 200 applications for leave, and those get divided by 4. So each clerk has 25% of that number. And on each of those, they're going to be writing me a memo. And there's one Friday in the month when all of those are due, but I'm reviewing them as we go along. And those are basically in a Dropbox like account where we can both look at each other. We can look at the work and I can make comments and ask further questions if I have them, and they can, but usually they'll make a recommendation. I think the court should deny leave because, X, Y, and Z. And assuming I agree, I tell them I agree, and then we don't spend much time on that at all. The second bucket of work is preparing for conference. Our court conference is every Wednesday, unless we have oral arguments in a given week. But at conference, we will have a list of cases that one or more justices felt like we should talk about at the table, that it was not an easy deny for all 7 offices. Maybe it's the opposite of an easy deny for all 7 offices, or usually it's somewhere in between. There might be 2 or 3 justices who see something that merits some conversation. Those cases take a little more work usually. And so the clerks, again, divide up the conference cases. In every given week, there might be 25 conference cases. And they need a deeper dive. And they do prepare a memo in those as well. And they get those to me the Friday before conference. I review them every weekend. This is a bad habit. Figure out how I don't have to put Saturday and Sunday into my regular work rotation. But that's the habit that I've gotten in. I send them any and all feedback by the end of the weekend so that Monday we can, if we feel like we need to be circulating a memo to my colleagues about one of those cases, or we know we want to pass the case because we think we need to look at the record a little more closely, or I know I need them to do a lot more work. We have some time to do it. And then we have our follow-up conversations about it Monday and Tuesday. And then Wednesday after conference, I rally with the whole team and we talk about what happened in the conference with all of those cases, what the follow-up work is. I always ask, who do I owe what to? What am I forgetting? And we go from there. Then the final bucket are the cases that we are formally hearing at oral argument. And those cases obviously get the deepest dive of all. And we have oral arguments once a month, except for the summer months. And we usually hear 12 to 14 cases. So each clerk is preparing 4, maybe 5 cases. And on those, we have a lot of individual back and forth as we get closer and closer to the argument. They do make an initial recommendation to me, and then we have a lot of back and forth before the argument. If we draw the opinion, that clerk who prepared the memo for oral argument is the one who works on the opinion with me. I'm a lot like Rhonda. We do a lot of drafts. I'm a big believer in, call them crappy first drafts. I always feel terrible for the clerk who is sitting on something so long because she wants it to be perfect and doesn't want to get it to me. And I always tell her, crappy first drafts are great because honestly, sometimes that's when I might see some of the bigger structural problems that they're kind of struggling with. And I'll think oh, wait a minute, I think actually we need this other section, or we need to explain this other thing first, so I actually like to be in early, which does mean that we end up doing a lot more drafts. But I think that's part of what I give the clerks, who give me an awful lot, is the more we're intimately involved in a draft of something, and I do that with conference memos as well as draft opinions, I hope the more they learn. So it is a work-intensive process. I hope it's helpful to them. How about you, Beth?
So there's some that I do that's similar, and I don't want to be too repetitive. Like Bridget described, I kind of have instead of three buckets, I really have two types of cases that we're working on. One are, as I said, we're not discretionary, so we're not deciding whether to take appeals. We're deciding how they're going to be handled. So that first process, our conference process, we split them all up. Everybody writes a memo. We don't normally discuss them verbally unless because there's just a lot of them in that first sort of conference. But if someone, they all know and I trust them to flag, ones, this one, we have a group of lawyers, as I know my colleagues do in the court, who look at things first. The office of counsel is what they're called for us, and then they're sending them to us, and then we're giving them an individual look. So this is sort of the second set of eyes, and we go back a lot with questions and say, what is this, what do you think? And I really rely on them really heavily during that, in that first sort of conference process where we're deciding. And our court has two tracks. One is decide cases in what we call memorandum decisions without argument, and those are primarily decisions based on briefs in the record, or we bring them in onto one of our oral argument dockets. And so once we decide that a case is coming in on an oral argument docket, that's sort of the second category. Our cases are assigned before they're argued to an individual justice. So we will know if we are assigned to the majority opinion, assuming we stay in the majority. And I know this is probably true with my friends, is, about 90% of our decisions are 5-0. And so, there's a good chance we're going to stay in the majority in a particular case. Sometimes they flip and then we handle that. But I like to have my clerks, whether we're preparing for cases assigned to us or other justices, do a memo. And we've gone through a whole process on how that memo can be most helpful, what I really need, the depth of review. Of course, that depth will be a little bit more if you're preparing to write the majority opinion. And then we also have a meeting where each of them present the cases that are coming for oral argument to each other. And I think it's just a nice way, first of all, for our term clerk to learn how to verbally, to keep those verbal skills, but also for everybody else just to be able to present it. I think it's a good skill to continue to have. Again, as we've talked about, these are jobs where you are spending a lot of time reading and by yourself. And I think that interaction is good, just enjoyable. In addition to being necessary, it's enjoyable to sit and talk about and have somebody shoot darts into a particular position or say, well, what about this case? Did you think of it? And, with three career clerks, they're looking at our law all the time. And so they are even more conversant than I am in some of these minute issues, standard of review issues, some of the kind of mundane procedural parts of our job, which I love, but it may sound boring. And so we do a lot of that verbal back and forth, much like my colleagues. And so that's kind of a little glimpse. I don't want to repeat because I agree with some of the other observations about the value of working together and drafts and all of that. All that's important. And I want to shift us over before we get too much further along over to writing style. We gave you a little preview of that at the beginning, but we all care a lot about the opinions we write being understood by the litigants as well as being useful for the lawyers as a statement of the law in our state. That's what's cool about a state Supreme Court, is that you are announcing and clarifying and sometimes settling issues that have been unsettled for some period of time. It's a big responsibility, and how you say that matters. And some of our opinions are not so glamorous and they're routine, but those litigants deserve every bit of care and consideration, as do the ones who might be talked about in the newspaper. So I'm going to phrase this question in terms of how you describe your writing style to your law clerks when you are interviewing, training, mentoring. How do you describe how you want them to write? And so, Bridget, I'll let you lead this one on.
So it's another great way to think about it. And I have to confess that I'm not sure I have described my writing style to my law clerks. My senior clerk does make sure, most of them do this before they even come to an interview, but make sure they've read all of my opinions before they start drafting. And that gives them a pretty good sense. Although I would say Bridget 2022 is a much better writer than Bridget 2013. At least I think she is. So I want them to start with the most recent ones and they can skim the older ones. But when I'm working back and forth with them, I have fantastic law clerks, really smart, talented writers, talented researchers. It is unbelievable to me how overwritten so much of their first drafts can be. And by overwritten, I mean the extra words that are, I don't know, fancy words they learned in law school that don't add much to a sentence. And so our back and forth is always, the only thing I like better than a 2-word sentence is a 1-word sentence. So how are we going to make this sentence have fewer words? And how are we going to make this section of the argument have fewer paragraphs? How can we say this more clearly? Which can take a lot of extra work, actually. So I work really hard on clarity and plain English. Like I said before, I don't want to repeat myself. It does feel very important to me. I mean, I don't wish it on anyone to have to, any citizen of the state of Michigan to have to read all of the opinions the Michigan Supreme Court issues in any given term. But I certainly want any citizen who is interested in reading all of the opinions that the Michigan Supreme Court issues, or at least all of mine, to be able to understand what they say and what they mean and what, as you put it, Beth, what the law is. It's only fair that people can understand clearly what it is, what the rules of society are. So I work really hard on clarity with my clerks. But I have some other little, I'm not sure how important these are. I'm very anti footnote. I don't think it makes sense to make people have to, and regular people are like, what is this? If you send an opinion to my dad, for example, he's like, what is with why do I have to do this up and down to the footnotes? What is that about? It's so terrible. Like, why are you trying to confuse me? It feels like it's a trick we're playing on the citizenry when we use footnotes. When a clerk starts a sentence with the word however, they're immediately fired. I'm just kidding. No, they're not, but they know better. And I have a few little things like that, but those are less important. So what about you, Beth?
So you're wanting to start it up on footnotes, huh?
So terrible.
So I am a citation and footnote girl. That's just how I am. I think the citations clutter up the text and make a mess. And you can just park them neatly in a footnote. And if someone cares enough to know what site in the Southeast Second this case is, they will be glad to look there. But anyway, I won't respond any more than that on footnotes. I'm also a big plain language. A couple of little things I would add or describe is I do have a list of banned words. I'm a one-woman effort to try to remove some words from the vernacular of the Supreme Court of Appeals of West Virginia. I'm not winning in any way, but I am trying to eradicate. I need to use a strong word, eradicate the use of instant case because it makes me crazy. It's just this case. There's nothing instant about it. And so my colleagues still use it. Sometimes it hurts to read their opinions. But we do, like many other courts, give great deference to each other when we're writing the majority opinion, as long as it's correct and it meets our standards of a statement of the law. We don't generally mess with each other's styles. I'm just trying to influence them by good example, which is working a little bit. I don't like the big words. That's my 20 banned words, including instant case. I don't love moreovers and howevers, and I love Bridget's description of if a 2-word sentence is fine and a 1-word sentence is better. You don't need that many words, and it's remarkable. I've had folks writing where it's beautiful. I mean, the legal analysis is pristine and spot on, but it's just there's so many words. You just have to get some of those words out of the way so that your meaning can come through. I am a big fan of Brian Garner, and he's really the first person I heard describe early in my tenure that you're really writing for not necessarily lawyers. And I never really had thought about that because I was a lawyer, and I thought, well, who else is reading these? But when you're the judge, you realize that there are parties and litigants, and I want them to be able to understand their case. Complicated things, I don't dumb them down. Of course, tax matters, very technical things sometimes have to be very technical, but you can still explain them in a way, I think, that makes sense. It's harder, and sometimes the parties are not speaking very clearly, but I certainly try to speak clearly in plain language. How about you, Rhonda? Do you want to weigh in on the footnote thing?
Yeah. Well, so I'm the John Roberts of footnotes because I put them in the text, citations in the text in the majority opinion, because I think it goes back to this intermediate court of appeals experience that I feel like lawyers in the other courts, when they're reading a majority opinion, they want to be able to cite and find the law and find where, the authority. But in a dissent, they always go in the footnotes because I feel like in the dissent, it clutters up my clear argument to why the court got it wrong. And so I want them just to be able to read, me telling why the majority of my court is so clearly, off the mark. And so I don't want to, mess it up with like 432 Southwest 3rd, whatever, 896 in the middle of my very persuasive argument. And especially if I'm trying to like flip a colleague. So I'm a little bit of a mixed bag. I will say, I think a lot of, this goes back to teaching, that if you think about like an essay exam at law school, they would give you like all these crazy facts. And then you'd have to like pick, certain facts and like spot issues, right? And then you'd write this, exam answer. But you didn't use all of the facts, right? In this crazy fact pattern, you just pulled which ones out. And so the same thing is when we're writing an opinion, don't put all those facts in there that are relevant. We only want the ones that are relevant to the issue that's in front of us. I say if you're, my clerk's a new clerk, we'll write a bunch of facts. And I say, if you can't find that fact in the analysis, then go back and like take it out of the fact section. Like it's gone, unless you need like that one little, 2 or 3 sentence to explain, who the main characters are in our story or whatever. But other than that, if you don't need that fact, to explain why we got there, then get rid of it. Like, I don't want to know. Who cares if the murder happened on January 1st, 1982, unless it's relevant, that's 30 years later, they're asking for new scientific evidence and testing, right? Or something like that. Otherwise, it doesn't matter. Do not give me dates. So anyway, I'm sorry, I got off, I get very upset about poor writing. Not that I'm an expert, but, clear, simple, concise.
Wow, we don't often see Rhonda get that wound up. And
I get very emotional. She
is very passionate about this. So
I'm
thank you.
passionate
And hopefully the students can see that, this is not just sort of a, something we do and we're political. I mean, we care a lot about this. At least the 3 of us do, and I know many, many of our colleagues do. We put a lot of time and thought into it, and we do embrace our nerdness happily, actually. And so now it is time for our lightning round. This is a part of the podcast where we give quick answers to questions that may or may not have anything to do with our work or today's topic. And we will answer them today, as we often do, in alphabetical state order: Arkansas, Michigan, and West Virginia. Question number 1: do you have a summer vacation planned, and what is it?
Yes, Alaska.
Whoa, really? That's so cool.
Yes. Do you want to come?
Yeah, I do. I don't really have a vacation exactly, but that's because summer in Michigan is amazing and everybody probably wants to vacation here. So we are hoping to do a lot of biking in western and northern Michigan, but no out of state vacation planned. Beth?
So we are going to take a little river cruise from Amsterdam to Budapest. So that should be really cool. Our second question is, who is a judge or justice, past or present, whose writing you admire or try to emulate?
I love that I get to go first. I would say Justice Elena Kagan. I think she's one of the best writers on the Supreme Court.
Well, I wanted to go first to say Justice Elena Kagan. Justice Scalia was a fantastic writer as well, in my view. But I think right now, Justice Kagan's writing is the most engaging, the clearest, and the writing I like the best.
And so my answer is the same. I don't think we've ever answered this question before, but just for a little variety, I will point out that I am inspired by Justice Thomas, who in all of his years on the court, agree or disagree with him, has stuck to positions that he believes in and isn't afraid to be, a justice of one in certain dissents. And sometimes when you believe, that something is incorrect, as Rhonda was explaining a minute ago, you just have to stick with it. And so I also admire his persistence. Question 3. How do you answer your telephone at the office? Do we even get calls at the office anymore? I don't even know. And is it the same as how you answer your cell phone?
Yeah, so if I answered my phone at my office, assuming it rang ever, I don't answer it because if it's ringing, it's spam, because nobody calls me at the office, but I just say hello. Same thing on my cell.
Yeah, anybody who's calling my office is not calling my direct number, so I am unlikely to be the person answering the call. If it's getting transferred to the phone that's in my office, somebody else has already answered it and told me who they're sending over, so it's a pretty informal answer. And my cell phone always tells me who's calling, and so it depends who's calling how I answer it. And if you need to know more, we can talk more. But if I don't know who's calling, if it's just a number, I don't answer it. I wait and figure out later who it is.
Those are all good tips. I, for many years answered the phone with my name, and I stuck to that for a long time, even on cell phone. But it got to be kind of ridiculous because you can see who's calling. No one does call my office anymore, although occasionally I'll answer just to throw somebody off, and I will say my name. But normally it's just hello. Sometimes my name depends on if it's someone very official calling. Sometimes I'll say my name. Okay, so our last lightning round question. What is the funniest or most memorable thing you've witnessed, either ever or recently, during a Zoom meeting?
Yeah, so I don't have the only thing I have is I just had one of those where I had like a green screen behind me at my home, and I was doing like a live TV interview, and my dogs came up behind it and started like knocking it behind me. So I was trying to like maintain composure live on TV, and I'm like two hands holding the thing. The whole contraption's falling over. One dog's jumping in my lap, and I'm just trying to like maintain any kind of sense of composure. And the whole thing's like falling over behind me. And then they're seeing my office half in the background, half the virtual, half who knows what. But no funny experience, just, a really uncomfortable and I guess a test to can I maintain composure or not.
I don't have any great. I think so many of the trial judges have like wonderful Zoom stories, and so that they'll have better answers. I have to say I've kind of enjoyed all the like pets and kids that I've seen in people's backgrounds and foregrounds, and that's been one of the upsides of a long couple of years. And I don't know, I think the Michigan Supreme Court was doing Zoom arguments maybe longer than West Virginia, although not Arkansas. You guys were in Zoom arguments for a long time as well, I think. And I was somewhat shocked that, a good year and a half into it, I was still walking certain lawyers of a certain age and a certain gender through how to unmute themselves, how to turn their camera on. And I've gotten so good at it. And I would just say like, okay, so in the bottom left-hand corner, and we're live streaming it, it's like in the bottom left-hand corner, there is a little thing that looks like a microphone. Click on that little thing, and then I would just talk them through it really. And the other justices on my court, the women justices, would be texting me like, laughing emojis. So sometimes the funniest thing was just, how are you not able to do this 2 years into this? Come on, somebody does everything for you. Is that what's going on? Anyway, Beth.
An excellent point. We did only do Zoom, quote, Zoom arguments for a short time. And the one that I remember is one of our justices, of course, we're all using backgrounds. And one of our justices was recused from a case. And so he had stepped away. And I don't remember if it was in the transition to the next case or whatever. but he came close enough to the camera that he was back in view and he was eating a piece of cake. And it was hilarious because it went out on live stream. And he's the kind of like, I would just laugh at that if I did it myself, or the time that my cat appeared on the live stream. But would be so concerned about that it was really actually hilarious. And there were some judges that got screenshots of it and may or may not have made memes out of it. So there we go. Let them eat cake. And so now, at this point, I will turn it over to Professor Oldfield and see if you all have any questions. I know we've come close to our committed hour, but we'd love to get a question or two.
I did successfully unmute myself.
Well done. It's that little microphone button.
I got it. So thank you all so much for joining us today. And we do want to be respectful of your time, but I appreciate that you're willing to take some questions. So I'll ask you to come up and use the handheld microphone so that it's recorded well, and give your name and ask your question. So who's going to go?
Hi, my name is Jared. I'm a 3L here at Akron. And thank you for taking the time out of your probably very busy schedules to speak with us too. My question was, I know you all talked about Elena Kagan's writing style and how you admired it. I was wondering if growing up as first generation attorneys and starting off your career, if there were any role models who really impacted how you either carried yourself in the courtroom or just your daily life.
Great question. Who wants to start?
I'll just start. I mean, female role models, there weren't any in Arkansas. I'll just be honest. Finally, the year I graduated law school was the year Arkansas had the first, I think, female justice. And she ended up not, I mean, she served, but she ended up leaving her term early in her second term, and just for, mental health and the issues. And she went on and has done remarkable things, but there weren't role models. What about you guys?
I'll just say that, and I know we've talked about this before, a lot of, we've talked about, I had a lot of role models who were men because it was mostly men. I mean, still the legal profession is still, as we sit here, in the year of our Lord 2022, 1/3 women only, in terms of practicing law. So they're just, and I think you find your mentors where you find your mentors, and you can still be inspired by someone of another gender. And I guess I never thought of myself as a woman lawyer. I just was trying to be a great lawyer. What about you, Bridget?
Yeah, I think we've talked about this before. I had the same experience. I mean, we're of a similar generation, and there were not a lot of women lawyers in the places I was practicing. Not none, but overwhelmingly men. And I feel very grateful that I had a lot of male mentors, faculty members, and then supervisors and colleagues who took an interest in my career and wanted to see me succeed. And I feel grateful to all of them. But they were primarily male mentors, and they deserve a lot of credit. And in addition to still there not being a similar number of women practicing law as men, it's even starker at the leadership level. So the leadership level, it's a little better in public service than it is in, private practice and in big law and in GC roles, but it's certainly not equal. So there's a lot of growing yet to do.
Hi, my name's Chris. I'm part-time 4L, so it's my last year here. I just had a question about, I forget who brought it up, but somebody brought up if you're reading a clerk's draft and you just say you don't feel comfortable. And I was wondering, keeping tools like Westlaw and Lexis in mind, at what point do you consider like a memo or a draft that you're comfortable with? How can you be like 100% confident or have very little doubt when you're reading something?
I mean, for me, I don't think there's a simple answer because it depends on the issue and the law clerk. And, at this point, my senior clerk, who's been with me for so long and was with the court even for 4 years before I got there, my comfort level with his work is very high, very early, which isn't to say that we don't have some drafts between us. We do, but not nearly as many as, the newest clerk. And the newest clerk, it'll take a little bit longer, but I think it's pretty issue/memo/clerk dependent for me.
And the only thing I would add to that is I also trust, the process. You have to trust your folks, and, you hire people you believe are going to do a great job and be thorough. But once these opinions start circulating to all of the law clerks of all of my colleagues, I just trust that folks are drilling down on this. We have, with 5 of us, 20 law clerks, and that's just a lot of legal horsepower, for lack of a better word. And I do trust that we're going to find it, and I do expect my clerks. I sort of goes without saying that they're not going to miss something. Has the court ever missed something? Of course, it's never perfect. Rhonda, what would you add?
Yeah, I'll just say that, I'm doing my own research and reading the case on my own, especially, a case that we're conferencing, doing a full opinion, first impression issue. Nothing's worse than to have your judge find a case that you missed and the parties missed. And so, that really pushes your clerks, because when they come into that conference with me, if I've found something in the record or, found something, a case that they missed, they want to do well, and they want, us to get it right. And, they want to have my best interest at heart, but they have the state of Arkansas's best interest at heart, and they want the court, to do well. And so there's a lot of motivation for, everyone to make sure that the ultimate decision is correct on the law.
We have time for one more question.
Sure. Are you guys good for one more?
One more.
All right, last question. My name is John. I'm a 3L. Every speaker that we've had has talked about plain language in decisions and publicly accessible judicial writing. I feel like a lot of the case law that we read in our first and second year at law school is the exact opposite of that. And do you think that might be influencing the direction that legal writing is going in current students today?
Well, I'll start and just say real quick that, I think that's a fair point, but I think you need, I hope that students are reading more recent opinions as well. And I know there are those tried and true false graph cases that are always going to be read, but I'm hopeful that, good professors like Professor Oakfield are also showing kind of the trends. And I'll just say one pet peeve, and this is, part of plain language. You have to be careful. I'm not a big fan of the justices trying to be funny and topical and pop culture references. I think that's going too far into trying to connect with your reader. I think you have to stop short of that, but I'll let the others talk.
Yeah, I actually completely agree with that. That there's definitely a line that feels not serious when it's crossed. But I agree with the question that a lot of what you read in law school is somewhat inaccessible, and that's too bad. But that is the way the law was for a long time. I do think there are more than a lady justice attempt to make writing clearer and simpler. I think a lot of judges are trying harder at that. We teach it in our judicial education classes, and like my colleagues, I try and, like Beth and Rhonda, I work on it with my colleagues' opinions, not always with success, but we're working on it.
Well, there we go. And so let me just say that is a wrap and the end of this episode of Lady Justice, Women of the Court. We want to thank Professor Oldfield and your whole class for this wonderful invitation and the opportunity to do another live podcast, which we really love to do. For our listeners, we will be back again soon. But in the meantime, please follow all of us and the podcast on social media and subscribe to our podcast using your favorite podcast app. And there we go.
Thanks for listening to Lady Justice, Women of the Court. Stay tuned for the Season 3 opening episode with special guest Chief Judge Jeffrey Sutton from the U.S. Sixth Circuit Court of Appeals. Chief Judge Sutton is the author of the nationally acclaimed book, 51 Imperfect Solutions, States and the Making of American Constitutional Law. Season 3 of Lady Justice launches Friday, September 16th in honor of Constitution Day. To learn more about this podcast, access past episodes, or find links to our social media, visit ladyjusticepod.com. You can also record a voice message with a question or comment. Subscribe to Lady Justice Women of the Court podcast for some exciting teaser trailers coming up in the next few weeks, leading up to the Season 3 premiere of Lady Justice Women of the Court podcast. Remember, the opinions expressed on the program are the justices alone and do not necessarily reflect the views of their respective courts. Until next time.